Construction Business and Law Manual for Nevada, Chapter 10, Nevada Licensing Laws. Overview. A contractor must be licensed to bid on or work on construction projects in Nevada. The Nevada Revised Statutes, NRS 624, contractors, and the Nevada Administrative Code, NAC 624, provide the details of the law under which contractors can become licensed and practice their trade in the state. The law establishes minimum qualifications under which a contractor can obtain a license. It also provides for penalties for anyone in Nevada who performs construction work without a license. The law has also established a licensing board, the State Contractors Board, which has been authorized to take disciplinary action against a licensee if necessary. A complete text of the statute, NRS 624, can be found in Appendix A, and the complete text of the Administrative Code, NAC 624, can be found in Appendix B. State Contractors Board. The Nevada State Contractors Board is committed to promoting integrity and professionalism in the construction industry in Nevada. By law, the Nevada State Contractors Board has the responsibility to promote quality construction in Nevada by licensed contractors through a licensing and enforcement system designed to protect the health, welfare, and safety of the public. The board is empowered with the following tasks: determining the qualifications of applicants prior to licensing, requiring applicants and licensees to prove financial responsibility, granting licenses, setting forth conditions for those licenses, such as limiting the field and scope of the operations of a licensed contractor, requiring licensees to post bonds, establishing maximum contractual limits, publicizing and communicating rules and regulations necessary for carrying out and enforcing NRS 624, requiring licensees to perform corrective work or take other corrective action, disciplining licensees found in violation of the statute, conducting criminal investigations of construction fraud, suspending a contractor's license if the licensee is prohibited from being awarded a public work project, requiring a financial statement and additional information for applicants and licensees, and determining what construction control services, NRS 627, disbursement of money by construction controls, and monetary limits on the aggregate total of contracts should be placed on contractors under specific conditions. Requirements for licensure. The procedures for determining applicant qualifications relating to licensure are contained in NRS 624-250 through 624-270. The board determines an applicant's qualifications for licensure by administration of written management and trade examinations, extensive and detailed investigations of the applicant's qualifications, background, ability, experience, competence, and general character, and requiring proof of financial responsibility using standards and criteria established by law. The process provides some assurance to the board and the public that a licensee is competent and qualified at the time of initial licensure. The contractor must submit a complete application that includes all necessary supporting documents and fees. Incomplete applications are returned to the applicant and will delay the licensure process. Therefore, it is very important that the contractor read the instructions provided with the application very carefully and check to see that all information has been included. Business name. The legal business name is the name that will appear on the license and is the actual name under which the contracting business will be conducted. If a fictitious name will be used, e.g. doing business as, that name must also be listed and filed. Copy of the fictitious name certificate must be included. Nevada law requires each licensee to conduct business using the name set forth on the license. If, at a later time, the licensee requests a business name change, the Nevada Contractors Board requires an application. However, this application cannot be used to change the type of business entity if, for example, the applicant's business will change from a sole proprietorship to a corporation, or if a merger has affected the business entity, then the licensee must apply for a new license. Resident agent. Nevada law requires all licensees to provide the name of the person physically located in the state to act as a resident agent for the service of process, including the street address, or other physical location in the state of Nevada, and, if different, the mailing address. Qualified employee. Each licensee must designate at least one person who will be the qualified employee. That person can be an owner, officer, member, manager, or employee of the company. A licensee may have more than one qualified employee, but each qualified employee must be a bona fide member or employee of the company. Qualified employee termination. If for any reason a qualified employee terminates employment or association with the license, the contractor is required to notify the State Contractors Board in writing within 10 days and replace that individual within 30 days. Failure to do so will result in an automatic suspension of the license. Required trade experience. The applicant must have had at least 4 years of experience as a journeyman, foreman, supervising employee, or contractor in the specific desired classification. Training received in a program offered at an accredited college or university or in an equivalent program accepted by the board may be used to satisfy a maximum of 3 years of experience. A journeyman is defined as a person who is fully qualified to perform work without supervision in the classification applied for or has successfully completed a program of apprenticeship that has been approved by the State Apprenticeship Council or equivalent program accepted by the board. Monetary limit. The monetary limit is the maximum contract amount a licensed contractor may undertake on one or more construction contracts on a single construction site or subdivision site for a single client. It is a violation of Nevada law to bid or contract in excess of the limit placed on the license by the board. The monetary limit is determined by factors set forth in NRS 624. Additionally, the board may establish an aggregate monetary limit on the contractor's license, which must be the maximum combined monetary limit on all contracts at any one time. Examination requirements. Both a management and trade examination is required for licensure. The trade examination will be specific to the classification applied for. In Nevada, it is a criminal offense to take an examination on behalf of another person or to provide any portion of an examination to another person. Industrial insurance requirements. Proof of compliance with the laws of the state of Nevada regarding industrial insurance will be required with the application and at the time of renewal. An application will be required to provide one of the following as proof of compliance: a certificate of liability insurance, commonly known as workers' compensation, covering employees for industrial injury and occupational diseases, written through an authorized carrier for the state. A copy of a certificate of qualification as a self-insured employer issued by the Commissioner of Insurance. A copy of a certificate issued to an association of self-insured public or private employers by the Commissioner of Insurance, or a signed affidavit stating exemption from the provisions. Contractors may receive an exemption if they have no employees, will not be a subcontractor for a principal contractor, and will not submit a bid on a job for a principal contractor or subcontractor. Child support information statement. To be in complete compliance with state and federal law, sole proprietorship applicants applying for licensure are required to complete and submit a child support information statement with their application for a contractor's license. Types of licenses. To obtain a license for a particular trade, a candidate must take and pass the test for each trade classification to the State Contractors Board. List primary trade classifications and subclassifications for which a license can be obtained. To obtain a license in most of the classifications, the contractor must pass a classification examination. The contractor must provide the board with the 4 notarized references verifying at least 4 years of work experience in a classification in order to apply for a license in the specific trade. License bond requirement. Nevada law requires a license bond for each license issued. The board determines the amount of the bond at the time the license is approved. The The bond can vary in amounts from $1,000 to $500,000 based on the type of license, monetary limit, past, present, or future financial responsibility, experience, and character of the applicant. After a license has been approved, the contractor will receive notification of the amount of bond required. A surety bond or a cash deposit will be required for the designated amount. Surety bonds must be executed on the form provided by the board and written by a surety company with an A rating or better, and cash deposits must be in the form of a cashier's check for the full amount of the bond. Failure by a licensee to maintain the required bond will result in an automatic suspension of the license. Requirements for the license renewal. The board will issue a license for 2 years. The contractor must renew the license by the expiration date shown on the license certificate. If the contractor fails to meet the renewal date, the license is subject to automatic suspension. The license may be reinstated within 6 months of the expiration. If the expiration period goes beyond the 6-month period, the board may cancel the license. If the license is canceled, the licensee must submit a new application for relicensure. A contractor may apply for inactive status if the license is valid at the time of the request. While the license is on inactive status, a contractor may not perform any work that requires a contractor's license in the state. During this period, the license must still be renewed, although the renewal fee is less than that of an active license. There is no bond requirement during the time the license is inactive. Consumer protection. The Nevada State Contractors Board can help consumers in the event that a licensed contractor has not done what was agreed upon or the work performed does not meet the standard of the industry. Before filing a complaint, the consumer is encouraged to contact the contractor, talk about the problems together, and try to reach an agreement. Many complaints can be resolved by honest communication between the parties. Contractors should make every effort to address a consumer's concern before a formal complaint is filed. If talking does not solve the problem, the consumer should make a list of the complaints and provide a copy to the contractor, suggesting a reasonable time for response. If a consumer files a complaint with the board staff will determine the validity of the complaint and issue a notice to correct as applicable. Failure to comply with the notice can result in disciplinary action against the licensee. Residential Recovery Fund. The state of Nevada has established a residential recovery fund for the benefit of Nevada homeowners who contract with a licensed contractor. Under certain conditions, the fund provides limited monetary compensation to single-family homeowners in the event that they have been damaged by a licensed contractor, their failure to appropriately execute a contract, and have exhausted all other means of recovery. Applicants to the recovery fund must apply within 4 years after the completion or termination of the work. If the applicant has obtained a judgment from a Nevada court, that applicant may apply for payment within 2 years from the date of the judgment, provided certain conditions are met. The decision will be made regarding an applicant's eligibility after the Nevada State Contractors Board has conducted an investigation. The fund is created from assessments paid by contractors who participate in construction, remodel, repair, or improvement to residential housing. These are defined as qualified services. The amount of the assessment is based on the monetary limit placed on the license. A residential contractor must pay biennial assessment to the fund based on the monetary limit of the license. Before a license is issued, each applicant must either register with the fund or complete a certificate of exemption. Contractors must provide their residential customers with a written statement that explains their rights and protections under the recovery fund. The following statements in 10.1 is an example of the information that must be provided to the residential customer by the contractor. Figure 10-1, Recovery Fund Statement to Residential Customer. Residential Construction Recovery Fund. Payment may be available from the recovery fund if you are damaged financially by a project performed on your residence pursuant to a contract. including construction, remodeling, repair, or other improvements, and the damage resulted from certain specified violations of Nevada law by a contractor licensed in the state. To obtain information relating to the Recovery Fund or to file a claim for recovery from the Recovery Fund, you may contact one of the State Contractors Board offices. Note: notice must include the address and phone number of each board office. An injured person is eligible for recovery from the fund's account if the board finds that the injured person suffered actual real damages as a result of the act or omission of a residential contractor that violated the law. The Residential Recovery Fund will not reimburse damages collected by other means, and recovery of entire loss is not guaranteed. For more information, refer to http://www.nvcontractorboard.com/res_recovery.html. Required contractor disclosures. Nevada requires that contractors include a license number and a license's monetary limits with bids. A general contractor must also provide the following information in writing to a residential owner who has contracted for construction services. 1. Name, license number, business address, telephone number, and all subcontractors and material suppliers who will furnish material with a value of $500 or more to be used on the project. 2. A notice that subcontractors or material suppliers may record a notice of lien upon the residence of the owner in any building or structure on the owner's property. 3. Information regarding the steps that the owner may take to protect against liens. Financial responsibility. A licensee or applicant for a contractor's license must prove financial responsibility by demonstrating past and current financial solvency and expectations for financial solvency in the future. The board will require a financial statement, bank account verification forms, credit reports, and any other information considered necessary to evaluate financial responsibility. Additionally, the board is authorized to require a financial statement and additional relevant information to establish financial responsibility of applicants and licensees who perform residential construction. The board can also determine if it is in the best interest of the public to require the contractor to use construction control services or establish an aggregate monetary limit on the contractor's license, which must be the maximum combined monetary limit on all contracts. Under Nevada revised statutes, disciplinary actions by the board, a licensee is subject to disciplinary action by the board for failure to comply with the requirements of the laws or regulations governing contractors. Violations may result in board action against the contractor's license. The State Contractors Board has the power to regulate contractors and discipline licensees who violate NRS 624. Disciplinary action by the board may consist of a fine of up to $50,000 per offense, an order for corrective action, suspension, revocation of the license, or other action. The licensee can also be assessed the cost of the investigation. Some of the violations of NRS 624 by licensees for which the board can take disciplinary action are substandard workmanship, failure to comply with a notice to correct, failure to comply for materials and services, failure to pay for materials and services, failure to complete a project, failure to comply with the terms of a contract, failure to provide required lien notices, failure to establish financial responsibility, failure to include the monetary license limit on a bid or contract, failure to keep in force a bond or cash deposit, bidding or contracting beyond the scope of the licensee, bidding or contracting in excess of the monetary limit placed on the license, contracting with an unlicensed subcontractor, failure to provide residential notices, failure to cooperate in an investigation, commission a fraudulent act or deceitful act, failure to respond to a written request from the board, submitting false payroll information on a public works project, failure to provide accurate information to the board, aiding an unlicensed person to evade the provisions of NRS 624, diversion of funds. In addition to being subject to disciplinary action, diversion of funds is a criminal offense in the state of Nevada. Upon commencement of disciplinary action, the licensee must provide a current financial statement and statement indicating the number of building permits and construction permits completed for the prior year. Nevada law also provides for discipline, including revocation of a Nevada contractor's license when that licensee has been disciplined in another state. Requirements for prompt payment. The following requirements for prompt payment to contractors by the owners and for prompt payment by contractors to subcontractors have also been included in NRS 624. This section does not apply to a residential contractor who performs quality services on a single-family residence or a public work. An owner of real property who enters into a written contract with a contractor for work on a project must pay the contractor on or before the scheduled payment date noted in the contract, if no schedule has been established. If the contract was an oral one, the owner must pay the contractor within 21 days after the date the contractor submits a request for payment. When the work has been completed, any amount of money that has not been paid to the contractor for work performed satisfactorily must be paid within 30 days after the occupancy or use by the owner or by a person acting with the authority of the owner. If the property has not been occupied, the contractor must have given a written notice of availability to the owner on or before the day that the property became available for use or occupancy. If payment is not made by 30-day period and there is no fixed rate of interest established in the contract, then the owner must pay interest at a rate equal to the prime rate at the largest bank in Nevada on either January 1 or July 1, immediately preceding the date of the transaction, plus 4%. This rate will apply to all money owed from the time payment became due. The following list describes the conditions under which an owner may withhold money from a contractor. The owner is authorized by contract to withhold a sum of money for retention. The owner may withhold an amount equal to the value of any work or labor that has not been performed. The owner may withhold an amount equal to the value of materials or equipment that has not been furnished for which payment is being sought. The owner may withhold reasonable costs and expenses necessary to correct or repair any work that is subject to the payment request. Each contractor must distribute money paid, including any interest, to subcontractors and suppliers within 15 days after the receipt of money from the owner. If the contractor does not make these payments within 15 days after the date the money was received, the payment will accrue interest at a rate agreed upon by the parties, or at a rate equal to the lowest daily prime rate plus 4% until the date of payment. Requirements for residential pool and spa contractors. Applicants who plan to work on the repair or construction of a residential pool or spa are subject to provisions of NRS 624.900 through NRS 624.965 and NAC 624.9695 through NAC 624.697, as well as other provisions of NRS 624 and NAC 624 governing contractors. The following is a partial list of the law's provisions that relate specifically to residential pool and spa builders. These provisions came effective in 2005. Homeowners have the right to contact the board's office with any question concerning their written contract. Contract requirements. A pool or spa construction or renovation contract must comply with the provisions of the law regarding required specific information. These provisions include limitation on the amount of down payment or advance deposit required, a maximum of $1,000 or 10%, whichever is less, payment schedules, lien release information, agreement regarding payment of subcontractors and suppliers, disclosures required to be provided to the homeowner, list of subcontractors, all, who will be working on the project, and signature on the written contract of the contractor or persons named on the license. Supervisory requirements. Supervisory requirements. The work performed must be supervised and controlled directly by the qualified employee or qualified agent of the contractor. Consumer Protection Board, bond. The contractor may be required to post a bond for the protection of consumers in an amount fixed by the board. A surety company whose long-term obligations are rated A or better by the national recognized rating agency must provide all bonds. Payment schedules. A schedule of payments must show the amount of each payment as a sum in dollars and cents. The schedule of payments must not exceed 100% of the value of the work performed on the project at any time. This amount excludes the initial down payment for which work had not yet been performed and any finance charges. Financing provision. A contractor who engages in the construction of a residential pool or spa cannot be officer, director, employee, or owner of a bonding company, finance company, or any other corporation or business entity who cosigns, underwrites, issues, sells, purchases, or acquires a loan to finance the repair or construction of a residential pool or spa. However, effective May 26, 2003, a contractor may own securities in a publicly traded bonding or finance company that provides pool loans as long as the contractor does not have a controlling interest. Thank you for reviewing Chapter 10 of the Construction Business and Law Manual for Nevada. Please move on to Chapter 11.